summary judgment on the issue of intentional interference. And the Supreme Court reversed and remanded that case. You may be familiar with that case. And the reason for that is because there's an issue of fact. That's what the New Hampshire Supreme Court said. There is an issue of fact. And there is an issue of fact in the intentional interference issue, and there is an issue of fact with regard to the negligence issue. So
I guess all I was going with the question was the city's not arguing that separate and distinct from the claims that have been brought as a matter of the court's general equity powers. The court should, in the event, and again, I'm still looking at the case law.
Yep.
I'm still going to look at the arguments. I haven't made up my mind on this question, but I just want to know the answer to the question. If the court determines that the claims for tortious interference, or perhaps getting ahead of myself on this, but the claim for negligent interference with contractual relations, if those claims don't survive independently, you're not arguing that the court should, as a separate matter, exercise its equity powers and grant you the relief you request.
I'm not going to waive that issue, Your Honor. I'm not going to waive that issue because I will tell you that under RSA 498:22, this court may hear as statutorily decreed. The court may hear and determine such cases as in the course of equity and grant writs of injunction whenever the same are necessary to prevent injustice. That is a broad, equitable power given and recognized statutorily. In the case of Hatch, H-A-T-C-H, in the 1927 case versus Hillsgrove, in Hatch, the New Hampshire Supreme Court said, Justice Snow said, that the equitable jurisdiction of the court predated the statutory provisions. So there, I'm not waiving that any argument that's separate and apart from intentional interference or negligence. This court doesn't have the equitable jurisdiction and power to craft equitable relief.
I understand.
I'm sorry, but
No, I just want, you've answered my question. I'm not sure I agree with the answer, but I appreciate that answer, and please continue with your presentation.
So, with regard to the legal issue, the purely legal issue, which is before the court, we asked this court to protect the economic relationship that exists between the municipal employer and its employees by way of a reasonably crafted injunction. We have suggested to the court certain distance, and the reason for the distances is not etched in granite. It is a suggestion, and I would not want this court to get hung up on it's 30 feet or nothing, or it's 50 feet or nothing, or it's 10 feet or nothing. I acknowledge that the United States Supreme Court cases have established distances, have upheld injunctions as far as 100 feet, where there's a fixed abortion clinic, down to 8 feet, which is the Hill case, the 2000 Hill case that the Supreme Court granted. So the question for you is what is fair and appropriate and reasonable, balancing the interests. One thing that I disagree with my brother is that First Amendment rights, be they speech, assembly, videotaping, are not absolute. He suggested that there is no balancing of interest to be involved. I'm a small player in this, but the United States Supreme Court, the First Circuit Court of Appeals, the New Hampshire Supreme Court have always recognized that First Amendment rights are not absolute. Never have been, never will be. Nobody has the right to use their freedom of expression in a way to harm other people. It's a balancing. It's a balancing act, and it's a tough balancing act that I acknowledge the court has. But I think that you've heard sufficient evidence based on probability that if this case were to go to a jury by way of the writ that's now been filed, that there is a reasonable likelihood of success, that a jury would return a verdict. That it-
If you would make sure that's turned off.
Yeah.
Thank you.
that there is a reasonable likelihood that a jury would find in favor of the city in protecting its economic interests in these employees. Because before the jury, there will not be this equitable injunction issue, 10 feet, 30 feet, 8 feet. It will be purely a question of fact. And the jury will be asked to look at the evidence, some of which you've heard, and determine whether a jury of 12 people of this county believes that there has been an interference with employment relations, or whether there's been a breach of a duty. Now again, my brother and I disagree with regard to the breach of duty, whether there is any duty. And I recognize that the first question of whether there's a duty is a legal call. But if you take a look at the situation where you've got a third party who comes into any employment relationship and creates a hostile work environment or an unsafe work environment, that the employer has a duty to that employee to protect them. And if a public corporation, if a private corporation employer would have the right to go to this court and seek an injunction against an individual coming into an office setting or an office setting outside, then certainly the municipal corporation employer has the same right. I want to address a number of things that Mr. Meyer touched on, if I may. First of all, the Glick case. I too am very familiar with the Glick case. Having argued in front of the First Circuit about 2 weeks ago, the other side of the Glick case. That was with regard to police officers. But one thing that the First Circuit says in Glick is that the recording, and it was about filming cops, the filming of police officers was done without any interference of the officers' performance of their duties. And that is significant. That is a significant limitation, because the holding suggests that if there were interference with the public employee's duties, then the right under the First Amendment is not absolute. And the court says that. Judge Lapid says that right at the outset. To be sure, the right to film is not without limitations. In Chablinski versus New Hampshire, U.S. Supreme Court, 1942, out of this jurisdiction, the right of free speech is not absolute at all times and under all circumstances. Which gets back to the balancing issue. Rights are not absolute. They are cognizant, or cognizable, they are afforded protection, and they can be balanced under an injunction. Most recently, the most recent case that is address this issue are the McCullough cases, MCCULLEN. One decided in 2013 and one decided in 2009, coming out of the First Circuit, both of which upheld zones of separation, because that's really what we're talking about. Some people talk about floating zones, fixed zones, but it's a zone of separation. And that's what we've been asking for in this case, a zone of separation. And it is for you to decide what the nature and degree of that zone of separation would be appropriate under these circumstances. Those two cases both upheld zones of separation. They were 35 feet zones of separation. The case of Hill, which is the United States Supreme Court case, decided in 2000, the United States Supreme Court talked about the issue of unwanted discussion. And you've heard evidence of that from the parking enforcement officers. And I know you've heard evidence to the contrary. And it's going to be your job and responsibility to weigh the credibility and reliability of that testimony. But the Supreme Court of the United States said an unwilling listener's interest in avoiding unwanted communications has been repeatedly identified in our cases. It is an aspect of the broader, quote, right to be let alone, end quote, that one of our wisest justices characterized as the most comprehensive of all rights, and a right most valued by civilized, he said men, I will say people. From all of this, the person sought to be influenced has the right to be left free, and his employer has the right to have him free. Now, is it in the same context of an employment relationship? No, it is not. But it is in the context of protesters, anti-abortion protesters, and people seeking medical advice for abortion. And in that case, which is the most recent and definitive statement about injunctions of protesters and balancing the rights, the conflicting rights, and I acknowledge this is an 8-foot zone of separation. And I'll tell you why, you probably know, but I'll tell you. The photographs that you have in evidence demonstrate that 2 parking meters is approximately 30 feet. It's not magic, it's not science, but everybody needs some kind of benchmark. And I've been calling it a football field, and maybe I'm too old for that anymore, but a zone of separation of 2 parking meters is about 15 feet. And I would invite you to go out and take a look at the meters. You'll see that 3 meters is about 30 feet. 2 meters is about 15 feet. And it depends on whether they're diagonal or horizontal or parallel. But it's some reasonable benchmark. And if there, I would also say, and if nobody's out there with a tape measure, you know, in the abortion clinic cases, they actually do put tape down. In the city of Concord, there is tape down around a clinic. In Boston, there is tape down. There is white marking. There isn't going to be any marking, and we're not requesting any marking. Because I know that if this court issues a reasonably crafted injunction against these defendants, that they will abide by that. And we will not be in here when somebody comes within X number of feet. That's just not going to happen, because there's an element of good faith on both sides of the fence on this issue. The case of that Mr. Meyer brought up, no, it was the I'm sorry, I'm blanking on the name, it had to do with the funeral services.
Oh, the Snyder case.
Snyder case, thank you. And I thought I had it in front of me, but in the Snyder case, again, the United States Supreme Court recognized that the protestations that were going on and the protestations that were entitled to go on were being done at a safe distance away, a safe remove. So that, yes, there were some protestations, but the court recognized that that could go on. But in the court decision, you will see that there's a safe distance. And the same thing with Glick. Glick talks about a safe remove, whatever that is. And what we're suggesting is that it is whatever you think it's going to be. Somewhere between 8 feet and 50 feet. And again, we're not suggesting that there's any precision with regard to a particular distance. The Second Circuit case, which has also been cited in the 4 memos that we have filed, and which I would incorporate into this argument, Your Honor.
And let me say this for both counsel in terms of legal memo. There's no need to restate any arguments. I'll review all the memoranda that have been submitted in the connection with the case.
And we know you will. But in the Second Circuit case, which came out in